So I think we'll get started, if that's okay. I see some of my students in the audience, and so I need to keep up the punctuality, them to know things start on time. Full speed ahead. So I am Professor David Baluarte. I direct the Immigrant Rights Clinic here at WNL, for those of you who I don't know. I want to thank the organizers today, both for putting together a fantastic program, but also for including immigration as a topic for discussion in these events to honor the life and work of Dr. Martin Luther King Jr. Dr. King famously said, injustice everywhere is a threat to justice, injustice anywhere is a threat to justice everywhere. And in September 1966, Dr. King sent a telegram to Cesar Chavez, who was in the midst of his own decades-long nonviolent battle to free farm workers and Latinos and other poor working people from the bonds of abuse and poverty. It read, "As brothers in the fight for equality, I extend the hand of fellowship and goodwill and wish continuing success to you and your members. We are together with you in spirit and in determination that our dreams for a better tomorrow will be realized." There are discernible differences between the work of the civil rights movement to combat modern-day vestiges of Jim Crow and the struggle for human dignity and rights for our country's immigrants. There are also many similarities. And I think we do honor to Dr. King's legacy to recognize those similarities here on this panel today, and by incorporating a discussion about immigration and the challenges faced by the immigrants in the United States on this panel entitled Immigration and Civil Rights. We have three great speakers to help illuminate important dimensions of the struggles of immigrants' rights in our country. I'll introduce each in the order in which they'll speak, and then I'll let them have at it. We will hopefully have a vibrant question and answer session at the end. First up will be Mary Bauer. She's the Executive Director of the Legal Aid Justice Center. She previously served as the Legal Director of the Southern Poverty Law Center based in Montgomery, Alabama, and is the Director of the Southern Poverty Law Center's Immigrant Justice Project. Ms. Bauer is the author of Close to Slavery, Guest Worker Programs in the United States, Under Siege, Life for Low-Income Latinos in the South, and the co-author of Injustice on Our Plates, Immigrant Women in the U.S. Food Industry. She has a BA from the College of William & Mary and graduated from UVA Law. Joseph Montano is the Immigrants' Rights Coordinator for the American Civil Liberties Union of Virginia. He works on a variety of civil liberties and civil rights issues, focusing on immigrants' rights for the ACLU, serving as an advocate before the Virginia General Assembly and regulatory agencies, commenting on legislation and regulations affecting immigrants in Virginia. Mr. Montano has a BA from George Mason and an MA from the London School of Economics in International Migration and Public Policy. And then finally, Claudia Cubas is the Program Director of the Adult Detainee Program at the Capital Area Immigrants' Rights, or CAIR, Coalition. In that capacity, she manages both the Virginia and Maryland legal jail visit programs that provide Know Your Rights presentations, pro se assistance, and pro bono placement services to detained immigrants in Virginia and Maryland. Prior to joining CAIR Coalition, Claudia served as an Equal Justice Works AmeriCorps Legal Fellow at the Central American Resource Center, CAIR, in Washington, D.C. Ms. Cubas also spent time in private immigration practice after law school at the University of Maryland School of Law. So we'll start with Mary. Thank you very much.
Thank you all for being here. And I'm going to talk a little bit about the experience of living in Alabama during the time that that state passed the most extreme anti-immigrant law that the nation has seen. a law known as HB 56. HB 56 was distinguished in many ways, but one of them was that it was a law that actually went into effect for an extended period of time, unlike the laws of most of the other states where it was enjoined. And I would say to anyone who thinks that the enforcement of immigration or enforcement actions in the world of immigration and immigrants' rights are not a civil rights issue, that Alabama is really a cautionary tale. HB 56 was sponsored in Alabama by Senator Scott Beeson, who urged his fellow legislators to, quote, empty the clip and do what needs to be done. That was his quote about immigration. The co-sponsor in the House was Representative Nikki Hammond, who said that the law was drafted to attack every aspect of an illegal immigrant's life. But this law was not entirely or even primarily an Alabama effort. It was drafted and heavily influenced by someone named Chris Kobach, who is with the Immigration Reform Law Institute. IRLI is a legal arm of the Federation for American Immigration Reform, FAIR, which is a group that has been listed as a hate group by the Southern Poverty Law Center, for which I worked. FAIR was designated as a hate group because, among other things, it accepted $1.2 million from the Pioneer Fund, a group founded to promote the genes of white colonials and that funds studies of race, intelligence, and genetics. FAIR also hired as key officials men who had joined white supremacist groups, had board members who wrote regularly for hate publications. It promotes racist conspiracy theories about Latinos and has produced television programming featuring white nationalists. So HB 56 was a law passed in Alabama, but its effects were felt in Alabama, but it was really part of a national effort to spread racist dogma. Certainly many of the people who supported it were not white supremacists, and so I don't mean to suggest that, but in terms of its history, that's part of the story. The law had 30 provisions. A few of those were enjoined early on by courts, but many of them actually went into effect. So the law contains such things as a provision making it illegal for undocumented immigrants to enter into contracts, making it illegal for people to provide harbor in terms of housing or food to undocumented immigrants, requiring that school officials inquire as to the legal status of both school children and their parents. Section 8, which prohibited many legal immigrants from attending Alabama universities at all. After HB 56 went into effect, SPLC and the other groups that we were working with started a hotline. That first weekend, we received over 1,000 calls. A few weeks in, we received more than 6,000 calls. And I'll just tell you a little bit about sort of the breadth of the issues and problems that we saw. A mother in northern Alabama called us to say that she couldn't attend a book fair because she didn't have a state-issued driver's license, a book fair at her daughter's school. A father called to report that his U.S. citizen daughter came home weeping from school after the other students told her that she didn't belong there and that she should go back to Mexico, a country she'd never visited. A judge advised a lawyer that a lawyer had the obligation to report her own client to ICE as undocumented. That same judge stated that he might have to report to ICE any person who asked for an interpreter, as such a request would be a red flag. Latino workers on a construction job site were threatened by a group of men with guns who told them to go back to Mexico and threatened to kill them if they were there the following day. The workers declined to report this crime to the police because of fears of what would happen to them if they did. A clerk at a store in Bessemer told a Latino man who was lawfully in the United States and who was from Ohio that he could not make a purchase with a bank card because he did not have Alabama state-issued driver's license. A victim of domestic violence went to court to obtain a protective order. The clerk told her she would be reported to ICE if she proceeded. A local bar association advised its lawyers that if they are asked to report information about their undocumented status to law enforcement, the requirements of HB 56 would override the legal representation to preserve a client's competences. By the first Monday after HB 56 went into effect, 2,285 Latino students were absent from schools across Alabama, which represented about 7% of the total Latino school population. In Madison County and in Decatur, public utilities announced they would not provide water, gas, or sewage service to people who could not prove their status. Probate offices throughout the state, including Montgomery, published notices indicating they would not provide any services to people who did not have immigration status. As a result, immigrants were unable to request birth or death certificates for family members. A worker called to say his employer, citing HB 56, refused to pay him and stated that the worker had no rights to be paid under the law. A mother spoke to the local office of the Department of Human Resources about the eligibility of her children, all U.S. citizens, for food stamps. The social worker told the mother that she would be reporting her, the mother, to the federal government for deportation. The family went into hiding. A Latino man was arrested and detained. While in jail, he was told he could not use the telephone to call his attorney because of the use of the phone would be a business transaction prohibited by HB 56. HB 56 was really a profound embarrassment to the state, caused a stain on the reputation of a state that already had a profoundly checkered history of racial injustice. But it was costly in other ways as well, economically. Dr. Samuel Addy, an economist in the Center for the Business and Economic Research at the University of Alabama, found that the law would shrink the state's economy by $2.3 billion a year and cost the state around 70,000 jobs. It would also cost the state about $1 million a day in lost tax revenue. In the end, the law was largely enjoined, almost entirely enjoined, after a period of approximately a year and a half. But it cost as well millions of dollars in attorney's fees that the state had to pay to resolve the case after the injunction was issued. So I would say, that was a success in the sense that the courts, that the plaintiffs in the case that I was involved in, prevailed in the court. But it was really a humanitarian crisis of profound degree. Tens of thousands of people left the state. But there were some really interesting bright spots, and those are the ones I want to talk about just a little bit and leave you with. And that was the reaction of people across Alabama. Initially, that polling suggested that a very large majority of people supported the law. By the end of the campaign against the law, I would say a slight majority opposed the law, and that was profoundly true in the African American community, where civil rights leaders stood up and spoke really movingly and beautifully about their opposition to the law. The Selma to Montgomery March that takes place every year as a reenactment in March was devoted that year to the rights of immigrants. And Jesse Jackson and Al Sharpton and many other civil rights leaders came to Selma and marched to Montgomery and spoke about HB 56 and the immigrants' rights. And I know there was a moment when Hank Sanders, who was a state senator in Alabama, who was a civil rights icon, a young man during the civil rights movement, African-American state senator, who stood up on the floor of the Alabama Senate and spoke so compellingly about his own childhood. And he said that when he was a young man growing up in Selma and he left his house, his mother often didn't know if he would make it home that night. And he wept before the other senators and said, that he was ashamed and that this was, as he saw it, the same story. And how is it any different for these kids today who might not make it home because they'd be picked up by ICE or the police or any other entity? And it was really quite a moving experience. And the other bright spot that came out of it, which was maybe the most important long-term for the state of Alabama, is that before HB 56 was passed, I don't remember ever seeing a single immigrant group in the halls of the legislature, the General Assembly, the legislature of Alabama. And after HB 56, it was impossible not to see dozens and dozens of Latino and other immigrant activists every single day in the General Assembly and the legislature, fighting against that law and fighting in solidarity with other people of color and fighting for a whole host of reforms in the state, many of which probably aren't going to come about anytime soon. But I think long term, it really profoundly changed the state in a really important and meaningful way. So that is my cautionary tale. I'm sure that people have questions and concerns that we'll get to at the end, but I wanted to share with you the experience of what state enforcement of immigration law looked like in the real world. And the real world, it's a pretty terrible experience. Thanks.
All right, good afternoon, everyone. My name is Joseph Montano, as David's already introduced me. So I just want to talk to you. I'm going to be really discussing the impact that the impact of having local law enforcement officials enforce federal immigration laws. And I'll be touching on the federal programs that enable this to happen, such as Secure Communities, the 287G program, and the Immigration and Customs Enforcement Detainers. But before I start, I really want to try to illustrate the sentiment and the level of animosity that was directed at immigrant communities during the time that these programs were rolled out. Prince William County in Northern Virginia was essentially ground zero for anti-immigrant sentiment and policy. The secretary of an organization called Help Save Manassas, who actually helped craft Prince William's crackdown on undocumented immigration, stated once that this issue is really not about immigration or illegality or legality. It's not about economics. I'm going to tell you right now what it's about. It's about an invasion of this country. This country is being invaded. No less than hordes of armed people were coming across its border. This invasion is not armed, but they do have weapons. And the weapons they carry are anchor babies. Now that kind of illustrates how Virginia was and the sentiment at the time of these programs when they were first rolled out. So as a result of this animosity, Prince William County made national headlines in 2007 when the Board of Supervisors enacted a new county ordinance which authorized local law enforcement to ask people about their immigration status, even if they were not suspected of any wrongdoing. So essentially this ordinance, what it would do is it would allow any police officer to pull over anyone they suspected of being an undocumented immigrant. Now, this begs the question, how can you assess, based on sight alone, whether or not someone is an undocumented immigrant? And the most clear and convincing answer is through racial profiling. Now, in 2008, the county amended the law because the county's lawyers were a little bit concerned about the legality, rightfully so, so that police could only ask about citizenship status after a person was arrested for an unrelated criminal offense. However, a federal program was then made available to all localities who wanted to participate in it and would again encourage racial profiling. This program was called the 287G program. Now, under the 287G program, a local law enforcement agency would enter into a memorandum of understanding with the Department of Homeland Security. The Department of Homeland Security would then deputize local law enforcement agents, so local police officers, and entrust them federal immigration responsibilities. So essentially, these 287G officers, as they came to be known, would have access to federal immigration databases. They could interrogate and arrest non-citizens believed to have violated federal immigration laws. Now, after the implementation of 287G, arrests for the single charge of driving without a license surged. When driving without a license, something that cannot be determined until a stop is already made, is the sole charge, it highly suggests racial discrimination. Now, the damage to community and police relations incurred by counties like Prince William, which administered the 287G program, stems from its encouragement of racial profiling and the deportation of people largely for minor and often traffic-related offenses during its implementation. The 287G program actually led to widespread racial discrimination practices across the country for any counties that wanted to participate in it. So much so that investigations by the Department of Justice were opened in a number of states. And as I'm sure you're familiar with Sheriff Joe Arpaio, that was essentially one of the cases that was opened. In Maricopa County, Arizona, the Department of Justice concluded that the Sheriff's Office engaged in a pattern and practice of racial profiling on Latinos, and that Latino drivers in certain parts of Maricopa County were actually up to 9 times more likely to be stopped than non-Latino drivers. In a separate Justice Department investigation conducted in North Carolina, the Sheriff's Office there was found to have engaged in a pattern and practice of constitutional violations by unlawfully detaining and arresting Latinos. The investigation found that Sheriff's deputies would set up checkpoints at entrances at Latino neighborhoods and wait for them to come by ask them if they had a license or not, or suspect them of being an undocumented immigrant, and just haul them off. And Latino drivers in that place were often arrested for traffic violations for which non-Latino drivers would only be issued citations. So in essence, the 287G program delegated authority to enforce federal immigration law to local police officers who had no accountability or oversight from the federal government, thereby allowing local police with demonstrated records of biased policing to continue racial profiling with impunity and with the backing of the federal government. Now, while some counties like Fairfax County resisted the implementation of the 287G program because they feared that if their police officers are seen as an extension of ICE, immigrant communities would be less likely to come forward to report crimes, which would in turn make the police officer's job a lot more difficult. Now, while Fairfax County didn't decide to participate in the 287G program, they did, however, implement the Secure Communities program. Now, Secure Communities is a Department of Homeland Security program designed to identify immigrants in U.S. jails who may be deportable under immigration law. And under Secure Communities, participating jails would submit an arrestee's fingerprints, not only to criminal databases as usually done, but to immigration databases. So when an individual is booked into jail, his or her fingerprints would be taken, sent to the Federal Bureau of Investigation, which is routine, to be checked against the criminal databases. But with Secure Communities, it'd also be sent to ICE, which would allow state and local law enforcement and ICE to automatically and immediately search the databases for an individual's criminal and immigration history. Now, unlike 287G, Secure Communities didn't require a memorandum of agreement with local police, and it did not deputize local police to enforce immigration laws. The way they sold this program to Fairfax County, which is a more liberal-leaning county, is that ICE claimed that Secure Communities would only really review the cases and prioritize the removal of criminal aliens and those who pose a threat to public safety and those who are repeat immigration violators. However, the program, as we found out, did not focus exclusively on convicted criminals, dangerous or violent offenders, or people who are threats to public safety or national security. In fact, what we saw was we've seen that Secure Communities was used to detain and deport large numbers of undocumented immigrants with no criminal records. I mean, one of the highest levels of conviction that they called it were for those people who were driving without a license or drunk in public. Now, when Secure Communities was first being implemented, there was a statewide concern that police officers may have an incentive, or at least the ability, to make arrests based solely on race or ethnicity, or to make pretextual arrests of a person they suspected to have been in violation of immigration laws, in order to have them run through the immigration databases once they are jailed. And that concern was really not unfounded. Most of us here, if we were to be pulled over and somehow absentmindedly we forgot our driver's license at home, we would be issued a summons for driving without a license, which is a Class 2 misdemeanor in Virginia, and then we would be sent on our way. However, under the 287G and Secure Communities program, driving without a license was an arrestable offense, so a pretextual arrest would be made. That individual would be sent to, their fingerprints would be sent to ICE. ICE would run the database, and then we would, they would issue what is called an ICE detainer, which I'll get to in a second. So with the Secure Communities program in effect in virtually every U.S. jurisdiction, many have argued that the 287Gs no longer served any plausible enforcement benefit because Secure Communities, all the fingerprints would be sent over to ICE officials who can then themselves determine whether or not to initiate removal proceedings. So back to the immigration detainer, which is a key component of both programs, 287G and Secure Communities. Immigration detainers were the principal mechanism for used to obtain custody of suspected immigration violators who are initially arrested by state or local law enforcement. But as I mentioned earlier, these are people who would, may have never committed a crime before, could be charged with driving without a license. I mean, there have been cases where individuals were arrested simply because they were fishing without a license, which is a crime, arrested for that, had their fingerprints run through the databases, and then deported. Essentially deportation proceedings would start. There was even cases where, in Arlington, I believe it was, there was a woman who called because she was a victim of domestic violence, and when she called the police, she mistakenly gave the wrong address. They arrested her for giving a wrong address to the police. She was then, her fingerprints were then run through the ICE database, and deportation proceedings were essentially followed after that. Now, one of the things that we really need to I want to highlight here is the problem that comes with programs like this. The problem is that it essentially encourages racial profiling on a level that's unheard of. And the particular problem in Virginia is because we're one of the few states, well, not one of the few states, but we are a state in which we don't have to keep a record, like police officers do not have to keep a record of who they pull over. So no demographic records are kept. So we have no access to data that shows whether or not a police officer pulled over a black person and how many black people he's pulled over, or a Latino person and how many Latinos he's pulled over on that shift. There's no requirement to submit some kind of data that essentially would let us know whether or not racial profiling is actually occurring. And the problem of racial profiling of immigrants, it's not limited to its borders. You know, across the country, people of color are being targeted based on their skin color or accents. And this is not immigration enforcement, so we have to call this what it is, racial profiling. Now, these unconstitutional policies discriminate on the basis of race and national origin and sweep U.S. citizens and lawful permanent residents up into this mess. These unconstitutional policies really discriminate on the basis of, like I said, it's discriminatory and unconstitutional, and we really have to stop it from ever being implemented ever again. One quick thing that I really want to say before I step off here would be in regards to ICE detainers. That's something that was a real big problem for us in Virginia. And at the ACLU of Virginia, we were working incredibly hard to limit the use or eliminate the use of ICE detainers. And I'm happy to say that after hounding the Attorney General, I'm sure he's gotten tired of reading my name in the mail, we were actually able to have him issue an opinion that states ICE detainers could potentially violate the Fourth Amendment, unlawful search and seizure, because what ICE detainers would do is they would keep someone for 48 hours longer than they should be, from the time when they should be released, excluding weekends and holidays. So let's think about that. Today is Martin Luther King Jr. Day, right? If, let's say my dad, who's a legal resident, but he does have a heavy accent, would get pulled over, he doesn't have his license on him, he would be arrested, his fingerprints would be then run through the database, and although he would be able to be released, let's say on that same day, on that Friday, he wouldn't be released that Friday because of the 48-hour rule. So he would then stay in prison Friday, Saturday, Sunday, Monday, Tuesday. So potentially 5 to 6 days he could stay in jail until ICE determined whether or not my dad would be is a legal resident or an undocumented immigrant. And I think that's the huge problem that we need to focus on addressing, that we shouldn't really relinquish our civil rights for any reason, but especially for a discriminatory policy. Thank you.
How are you? Good? I know I'm the last speaker, so just take a moment to kind of breathe in. We're almost done. So my name is Claudia Cubas. Thank you for the introduction, David, and thank you to Mary and Tony for speaking on very important issues that I've actually come across because I've spoken to the people that are detained after going through, either detained through discriminatory practices in state laws or ICE detainers or 287G programs or secure community programs in the various counties in Virginia. So just to give you a little bit of background, because I think it helps in terms of what I'm about to talk to today, I'm going to address two issues that I see as obstacles as in and of themselves whenever I'm assisting, either representing or mentoring or placing immigrants that are detained with pro bono counsel. And the first one is access to counsel. Unfortunately, the number of immigrants who are represented is a very low percentage, just in general, but the number of detained immigrants is even lower. And then the other issue is what happens when you get the person counsel. What are the issues that affect a person's due process rights as they go through the immigration court system? And because things don't end once a person gets represented, then it's actually about presenting a case, what are obstacles that you face when you're detained, about presenting evidence that you have with you or that is on you because it's torture or persecution on your body. So to give you kind of an overview, because I'm not sure how many of you are aware of the statistics in terms of detention. I'm going to kind of paint a picture and then address these two issues after you've seen the review of these stats. So on any given day, there are close to 34,000 immigrants detained by Immigration Customs Enforcement, otherwise known as ICE. And I can tell you that, definitely, because it's actually a congressional mandate. There is law that says that ICE has to keep over 34,000 beds full every day of the year. And what that means is that we've seen from 2011 to 2014 until now, record number of people being detained every year. So usually about 10 to 20% increments of people being detained every year. So from 2013, I can tell you that there were close to 500,000 immigrants. The number is more, 450,000 immigrants that were detained in 1 year. Also, in terms of detention centers, currently we have 205 detention centers nationwide. There was 250 detention centers in 2013. Now there's 2,005, so that's a good thing. There was a reduction. But the majority, over 65% of those detention centers, are not actual civil detention centers. So while everybody says, well, detention is not criminal, it's civil, that doesn't really actually pan out in practice, because the people are sitting in jails where inmates are housed. They may not be interacting with the inmates, the criminal inmates, but they're in a jail for all intents and purposes, so it looks like a criminal process. And in fact, to add to that, out of those 205 detention centers, 65% being criminal jails, almost, and I want to give you a specific, I would say over 70% are operating under detention standards that were established 15 years ago. I believe only 22 centers are actually operating under standards that were established in 2011. And that was still a long time ago. 2011 is 3 years ago. A lot has changed. In terms of the actual people who are going through the immigration process and are eligible, who have representation, the Stanford Immigration Clinic last year established that close to 39%, two-thirds of detained immigrants have no legal representation. So 30%, right? 35%. In terms of LOP, which is important for our organization because CAIR Coalition is considered a legal orientation program site. That means that we receive funding to carry out a government contract to provide Know Your Rights presentations, individual orientations, and either placement or pro se assistance to these detained immigrants. Close to 39% of participants in 2013 were represented. This is actually an increase from 2004, there was actually 22% in 2013, and now there's a 39%. So there's an actual increase, which is still relatively a low number. And in terms of well, why does it matter? Many people, perhaps you're thinking, well, maybe a lot of them don't qualify for relief. Well, it turns out, both in legal statistics found under legal programs that are operating under the legal orientation program, and also the Stanford report, that close to 75% of the people that are in detention are eligible for some type of defense, some type of relief from deportation, or at least to reduce the idea of taking a final deportation order. That's a lot of people that are eligible for relief, and very few of them are actually getting an attorney. So why is it that it's so hard, the first question, why is it so hard to represent these folks? Why is it that it's so hard to place these folks with pro bono counsel? Well, the first thing is that, remember the 205 detention centers that are currently open? Over 65% of them are located more than 1.5 hours from a major city. So it's really hard to place these people with pro bono attorneys when a pro bono attorney who agrees to representation has to drive 6 hours to meet with their client in an 8-hour workday. It's just hard. And not only that, but if these detention centers are operating with in terms of disparity of detention centers, some of them allow contact visits, some of them don't. What ends up happening is that some of these detention centers have actually denied access to these attorneys to meet with their clients. So that's one thing, and that's the most obvious thing. Pro bono attorneys just simply are, especially we place cases with medium to large firm attorneys, but also solo practitioners. Many of these attorneys think twice about taking on cases involving detained immigrants because they ask me, am I going to have to drive each time that I want to go meet with my client 6 hours or 5 hours? Or can I even talk to my client if I don't go and drive to this detention center? Can I talk to my client? Can I have him call me or anything? Well, another issue that affects this is that the detention standards, some of them allow for a lot of rec time, so that way they're outside of their cells, and some of them don't. The 2000 standards actually only require, within a 24-hour day, 1.5 hours of rec time. So that means that they're inside their jail. You do the math because I'm really bad at it. A majority of their 24 hours a day. So, and they say, well, they can still have rec. The jails will say, well, they can still have rec time. They have access. During the rec time, they can call their attorneys. Well, if the rec time happens to be at 7 p.m. or 5 a.m. or 11 p.m., no, they really can't, because the times that they can call and can make a call, their attorney is probably more than likely not to be there. In terms of another issue that is affecting the ability for organizations like CAIR Coalition, and there's other organizations, there's about 20 organizations that provide services, consistent services to detention centers. It's the ability, it's the fact that many of these people are not even in regular immigration court proceedings. Generally, some people that are a little bit knowledgeable of the immigration court process, they think, oh, the person is detained and then they're going to go before a judge and then the judge decides whether they stay or they leave. Well, that's not necessarily the case, because now, since 2012, there's been an increase of people in what is called expedited removal. That means that they get handed a document that says, we're going to deport you because of so-and-so reason, without ever seeing a judge. So that means that if I identify somebody that is potentially eligible for asylum or what have you, the first fight, and I always tell detainees this when I'm talking to them or giving them Know Your Rights presentations, well, there's two fights. The first fight is to get you to immigration court, and the second fight is to, once you get to immigration court, actually win your case. And so that affects our ability to place cases with pro bono attorneys, because the process between getting, identifying the person, getting an immigration court hearing, and then actually getting through the immigration court hearing can be anywhere between 4 to 6 months. And some of these pro bono attorneys aren't available for so long. And also, some of the clients may not even be available during that time at the detention center, because another issue that affects pro bono counsel is that they get transferred. ICE can transfer them wherever they want in any state. We've had instances where I met with a gentleman on one week. By the next week, I was shopping around to find a pro bono attorney. And when I came back to deliver a message and say, hey, I found your pro bono counsel, he was no longer there. He had been transferred to Etowah, Alabama, where there's, by the way, no organization that provides Know Your Rights presentations or goes and visits people at this jail where he was. In fact, he called me and said, there's no CAIR Coalition here. I'm like, yes, that's right. So even if I identify these folks, I can't place them if they're being transferred or if they're in jails where I don't have funding to go and visit them. And the last, issue that is affecting the ability to place these individuals with pro bono representation is that many of them are subject to mandatory detention. Usually the question is, well, why can't they be released? Why can't they ask for bond? Well, you can't ask for bond if the laws say that you're not eligible to ask for bond. And people who, I talked about how there's an increased number of people being placed in expedited removal where they don't even see a judge, where they have to fight to get to see a judge. Well, people in expedited removal are subject to mandatory detention. So that means that they're not eligible to ask for bond anywhere but the Ninth Circuit, because that has been recently changed in the Ninth Circuit. They're not eligible to get released on alternatives to detention, such as an ankle bracelet or any type of humanitarian release. And so they stay in detention for several months, 6 to 8 months. And that also is a problem because sometimes I've met people who are clearly eligible for a defense against deportation, but by the time that their case is finally moving along in the system, they're about to give up because they're tired of detained. It's re-traumatized them. If they weren't already traumatized, the persecution that they experienced or torture, now they're even more traumatized by the treatment that they experienced while in detention for the last 6 months while waiting for the reasonable fear interview or waiting to get placed or waiting for an immigration court hearing. And those are the challenges in terms of representing folks. And, there's a lot of good responses, I guess, solutions, potential solutions to this. Why, New York recently, New York City created a public defender model for immigrants that are detained, and now they have an immigration defender corps model where they recruit a number of recent law students and they represent clients. That's an option. Also, there are options of providing video teleconferencing systems to all these nonprofit organizations. We actually have one. But guess what? We're the only nonprofit organization that has it. There's 20 organizations right now currently working to place and meet with these folks, and we're the only organization that has gotten this video teleconferencing unit. So it's not just about asking, but also getting. And the law enforcement agency that can provide this teleconferencing system is ICE, the same agency that is trying to deport the potential client. So it's a very hard conflict of interest right there. Am I going to help the person that's trying to prevent the person from being deported that I want to deport? In terms of due process, once we do finally place cases, and we have been able to, every year we have been increasing the number of cases that we've placed with pro bono attorneys, there's also issues about due process. When you're detained for so long, detention, their studies have shown that the longer you stay in detention, both for criminal and immigrants, the more susceptible you are to mental illness, to depression. And that creates a situation where you have clients that are very needy in terms of their medical services, and if a client needs mental services and their psychiatric services or psychological services, then that sometimes overrides the legal service component. And you also have clients that go incompetent when they're in detention. We've had clients that are, or pro bono clients that were functionally schizophrenic at the beginning when we met them, and then by the end of their proceedings, they were completely incompetent. And that's because even though they might be subject to mandatory detention, there is no actual limit on the amount of time that a person can stay in detention. Once proceedings are ongoing, the person can stay in detention even if they win their case. If DHS or ICE, Immigration Customs Enforcement, appeals their case and ICE decides to keep them in detention, the likelihood, the average amount of time for the person to stay in detention is over a year now. So that obviously creates habeas concerns. Right? Another due process issue is when you're in immigration court, you have the responsibility to, when you're seeking some type of relief, you have the responsibility to establish evidence, to provide evidence to corroborate your claims. The burden is on the respondent, is on the immigrant that is applying for the defense he's seeking. Well, what that means is that it's going to be very important for that pro bono attorney to meet with their client, to create a declaration, to get any contact information from their client who can potentially corroborate their claims, and also to document anything, whether that the client has or that the client has experienced as a result of whatever trauma or that's important for their case. So asylum cases, those are usual types of defense. That's a common type of defense. So for asylum, you have to prove at least more than a 10% chance of persecution. And when you have a client that is a recent asylum seeker, they may just have come from Burundi or El Salvador, and they have nobody here, how do you corroborate their claim? Well, they can provide credible testimony, but if the evidence is on their body, then one way to do it would be to get a forensic evaluator to go and conduct an examination of your client and determine whether the scarring, etc., is, comports with what they're saying, how they obtain these scars, how they obtain these injuries. But what happens when the jail that is holding you says that you can't do this? That when there's no legal regulations explaining, or I guess addressing the ability for evaluators to go and conduct this evaluation? How can you hold your burden when the system that is holding you is saying that you can't actually get this person to evaluate you? We've had instances where, so pro bono attorneys have also have asked the judges to issue an order, but that doesn't matter because the judges don't have that discretion to tell ICE, allow this person to go and to have their forensic evaluator go and conduct an evaluation. So not only do we have issues in terms of judges' discretion and ability to address specific concerns that are going to go to evidentiary, evidence, but also procedures. You also have a situation where you have jails that are holding people with various detention standards, some that allow these evaluators, some that don't, some that allow interpreters without any security requirements to be established before the visit, and some that do. And so sometimes you just can't visit with your client, or you just can't conduct these evaluations. So, in terms of what practitioners like me start seeing is something like what happened in Artesia. Does everybody know? Did everybody hear something about the Artesia, the families that were being held at the Artesia Detention Center in New Mexico? Well, what happened is that ICE decided to hold close to 500 women and children in the detention center, and because there is no clear rules in terms of evaluations, client visitation hours, language, there was a lot of people who had cases that were being denied access to attorneys, that were being denied access to interpreters, or when they were being interviewed by asylum officers or by their attorneys, the ICE officer is standing right there, and there is no confidentiality. And so these are due process concerns, right? Because how can you be expected to win a case when there's no rules respecting or providing for the ability to actually fight it? Thank you so much. Thank you for your time.
We have a bit of time for questions. I'm gonna let you all sit on that information for a second. I'm a little bit overwhelmed myself, and I actually want to ask the first question to my friends here on the panel, and at the same time recognizing what you've all heard about is some really complicated bureaucratic mess. And so I want to encourage everyone, no matter the question, if you were sort of confused by information that was just presented to you, is there something that you'd like clarification on, please ask the question. We're kind of trying to get to the bottom of a pretty confusing, although really troubling, I think if you heard it, situation. But the question that I have is because I'm feeling kind of depressed right now, and I want to explore... I need to explore, if not a solution, at least a little bit of potentially good news that we've received. Many of you who, I don't know, read the papers or watch the news, know that in November of last year, a couple of months ago, the president made a big announcement, right? This executive action where there was going to be some relief for people who were facing deportation. Now, this executive action has been extremely contentious. There's an ongoing lawsuit in district court in Texas to enjoin this executive action. There have been bills presented by Congress. One actually just passed Congress to stem sort of the progress of this executive action. And we all know that this is going on, that there are efforts to stop it. I'd like to start off by asking the panelists, to what extent does this executive action address any of the issues that you just presented to us? If indeed there are civil rights concerns in the world of immigration regulation and enforcement, to what extent has this announcement of an executive action created the possibility of a better future for some? I guess maybe we can just sort of take it up in order of the presentations. Mary?
Sure. I mean, there are 11 million undocumented people in the United States. That's the estimate. 7% of the national workforce is undocumented, and this executive action is temporary relief for something less than half. That's the estimate. So it leaves a lot of people out. In my view, it's an unequivocally good thing in the sense that people can get, a legal document, they can have a relief from deportation, they can get a driver's license in lots of states. That is fair. But I just wanted to take a step back for a minute and talk about the immigration system, because I have gone to many, many sessions where people talk about, they want us to be supportive of immigrants, but they don't support undocumented immigrants who sort of won't get in line and play by the rules. And, I think in my experience and the experience of most advocates, they're just, for most people who are here out of status now, there is simply no line to get in to legalize your status. So people who are willing to, who are doing everything right, who have taken English classes and who pay their taxes and who work hard and who are, very valuable long-term members of the community who've been here 20 years. I mean, it's been 1986 since we had immigration reform. There's simply no way for large numbers of people to legalize their status. So I think we have to get out of the view of seeing kind of being out of status as some sort of refusal to play by the rules, because the rules stink. The rules don't allow people who are, long-term members of our community to ever have hope of legalizing their status. So I would say about this is that it's a small step. It's temporary. Another president can revoke it, but I'm glad that the president did it.
Yeah, I just want to add to that. I think that's a great point. Just a quick personal story. I mean, both of my parents came to this country as undocumented immigrants, and it took my dad until a year and a half ago to, be able to, or 2 years ago, I should say now, to be able to get lawful permanent status. And that's because of the backlog of immigration cases. I mean, it takes a horrendous amount of time to actually wait in this line that they say. He's paid taxes, he's taken the English classes. In fact, one of his English teachers taught him the song On the Road Again, which is now his favorite song because he's a bus driver. It's quite fitting that you should say that. But in terms of President Obama's executive order, what that would change is, the devil's in the details. So when I heard the speech, I stayed up with the folks from California who had it a little bit easier time-wise because we were 3 hours difference. So I was up till 11 midnight while they were, kind of cruising on 7, 8 o'clock at night. And we were just frantically exchanging emails once we saw that the new DHS memo policies were out, stating that it would be dismantling what I just spoke about, secure communities. They were trying to dismantle secure communities and implement a new program called PEP, I believe it is, Priority Enforcement Program. But we don't know what that looks like yet. So we're cautiously optimistic, but really it's going to take us reviewing how it's going to be implemented, because we've heard that line that we're only going to go after the most serious and hardened offenders, and it just hasn't happened with secure communities. So I'm a bit wary of it, but I'm cautiously optimistic in that regard.
So in terms of the executive action and what I've seen on the ground, I think it has had a very positive effect, in terms of the detention and the enforcement of these the rules, and I think it's changed a little bit even kind of the environment that the ICE is operating on. But these memos went to ICE. They didn't really address any problems with the court, and right now ICE gets more funding than the court. And so, there's no memos really addressing issues with the court. And right now, you have a court system where there's, for instance, perhaps maybe either 1, 2 law clerks to perhaps 6 judges perhaps the judges are seeing a docket of close to 10,000 cases and it's only 5 judges. Or you have no legal, you have a hiring freeze because funding has not increased. And so even though you want to, employ new law clerks or new judges, you can't. So I think in that aspect, it hasn't really addressed the issue in terms of, going through these cases and giving people some type of reprieve. I think in the enforcement, it has to a certain extent. The priorities were very, very focused, but I have seen a lot less people that are being detained on driving without a license or public intoxication, which, by the way, in Virginia, you can get arrested for just being, just drinking on the stoop of your house. So I've seen that decrease, but again, it's also regional. I think this field office, the ICE field office in Virginia, tends to be a very proactive field office. Not every ICE field office is the same nationwide, and the priorities that were established in terms of who is priority, it's criminal aliens, what they consider criminal aliens, but it's now recent asylum seekers, recent people crossing the border, and so what ends up happening is that you have asylum seekers who are being denied parole, so they can't get released, they have to apply for asylum while in detention. You get more, Steve Customs and Border Patrols more likely to issue a reinstatement order, which is somebody looking at their immigration history and saying, oh, they were previously deported in 2001, so since they were previously deported and they came back, now they're subject to expedited removal, so I don't even have to give them an immigration court, even though it's well within their discretion to issue a notice to appear, which is a document that actually creates an immigration court hearing. So you have those types of concerns that I believe the executive action may have incentivized even further, or may have perhaps increased it even further.
Well, thank you. I'm slightly less depressed now. Are there other questions for our panelists? Yes, Ms. Adams.
Claudia, I believe you talked a little bit about detention and immigration for the detention centers, and you talked a little bit about due process. And something that came to mind for me when you talked about due process is the fact that detained immigrants do not have the right to actually be in the courtroom, but in most cases are on a projector screen back and forth. Do you feel like that is a due process issue?
So I think, in my opinion, I think I'm beyond that because that is my reality. But I do agree nationwide that it is a due process concern, especially for the most vulnerable populations, which end up being the people that stay in detention. People that have mental illnesses, women that have been victims of pretty severe sexual or other type of trauma. And so it's very hard to, when your case is riding on a judge believing your story, it's very hard to establish credibility if the screen is going haywire while you're providing testimony, or if you're providing testimony but the camera is inside the courtroom is pointed to a corner in the ceiling and you don't know who you're speaking to. So I do think it's a due process concern. Unfortunately, the way that it's working, it seems like it's probably going to continue. There is, at least in the organization that I work for, there has been some movement to try to address this issue, especially for, again, the most vulnerable of the vulnerable population that is in detention. Good question.
Thank you. And to actually make the introduction complete, Claudia, Ashley Adams is the one that won Santos's case that you referred to our clinic. She might have a different opinion on whether it's a due process violation or not. Are there other questions for the panelists? Yes.
My question is for all three panelists. It's more of a general question. A lot of times when we speak of immigration, we hear of this idea that the system is broken. And you all spoke about, various activism and policies that have been enacted by either the executive office, which could be revocable, and then you talk about issues with individual representation. So, in your experience, what do you think are the preventative ways that individuals, such as us who are interested in immigration, to fix the system versus waiting for a problem to arise?
Advice on how we fix the system. Let's hear it. Maybe in the order of presentation, you have an insight for us, Mary?
I mean, I continue to think the answer is Congress, and that's a sad, sad place to be looking at this. I think there was a immigration reform passed in the 1980s by a conservative, with a conservative Republican president, so it doesn't have to be a partisan issue. But to me, that's the answer. There needs to be a fair, reasonable immigration reform. And I think, there's lots of things to be done at the margins in terms of making the system a little less abusive or getting a few more lawyers for people. But, I mean, that's not really the place I want to be. The place I want to be is a system that we overall think, we look at it and we think, this is fair, that people who, are part of our community and who work hard and who are, are decent people who, I mean, we're not going to round up 11 million people. None of us want to live in a society that would be produced by that. And so we should have a fair law. And that, at the end of the day, is, I think, the most important thing.
Yeah, I completely agree. I mean, legislation is really it's unfortunate, but it seems to be one of the only routes that we can take. Legislation that is going to be passed hopefully will be fair and practical. I mean, it's been stated, you can't round up 11 million people, but you also can't, be detaining people, violating someone's Fourth Amendment rights, practicing racial profiling. I mean, that's just simply unfair. And also, I think we should focus on, I mean, and this is a bit biased of me because, I work for the ACLU in Virginia, which is a Virginia affiliate, to look at things on a state level. I mean, what can you do advocacy-wise in your state, in your area, in your county even? Like, when it came to ICE detainers, what we actually did was, we really pushed hard for the Attorney General to see it our way, to understand that ICE detainers and ICE detainer request is a violation of the Fourth Amendment. That wasn't done through legislation, that was done purely through advocacy. And, like I said recently, a couple of weeks ago, the Attorney General actually agreed with our point of view and told sheriffs that they should not honor ICE detainers because it violates the Fourth Amendment, and it's just unreasonable.
So I'm going to agree with my colleagues, but I'm also going to give you a more practical answer because I'm on the ground. I always say I prefer court rather than meeting with a congressman or congresswoman. I want a practical response right away. So I would say I agree. New legislation is needed to perhaps redress some of the wrongs and perhaps undo some of the bad legislation that was passed since 1996, which was really bad. And also new legislation to address the issues that are rising. But I also think, practically speaking, what you can do is be bold in not being afraid to stick up for these issues and for these people in your small communities, especially in Virginia, or other southern states that have that have a history of discrimination and etc. But also be bold and don't be afraid to look at careers in the public interest field. My people that go to detention centers, the attorneys that go to detention centers, legal assistants, etc., there are few and far in between. It's a hard job to be going to these jails and meeting with these people, and not everybody can do it. Not everybody can do it, not everybody wants to do it, or people just don't know that it's a possibility. And I would say that, look into public interest law, because you can make a difference at least one person at a time. That's usually what it takes, in addition to new law.
Thank you. Other questions for our panelists? Yes.
I think this is a follow-up, actually. Is it Tony? No.
It's Joseph.
Joseph, sorry. So to what you just said, so it seems to me one of the, and this came out in Mary's talk too, I think, one of the really big problems is the lack of a firewall between local enforcement and ICE, right? And from your last comment, I got the impression that maybe there's some discretion at the state level or the local level about whether they want to put up a firewall, right? So say we're not going to give information to you, right, about immigrant status or whatever. Is that right? And if that is the case, or is there at least some ways there that you can resist kind of federal mandates to give information? Is that then, again, practically maybe a better way, given, you know, how worried I am about Congress passing this? At least in some communities, would that be a better way of trying to...
Well, I'm not too sure about, you know, the ability for them to not be able to implement this new executive order. Like, again, it's a new program and they'd have to really look at it. But there are other ways that, you know, local law enforcement can just refuse to do something. So, for instance, something that I've been trying to work on has been really what's called a victim witness bill, something that we were trying to push this legislative session. And what that would do is it would tell police officers that they could not ask for the immigration status of a victim or a witness to a crime. And I think that just like would restore public trust in our local police department, because what ends up happening is that when local immigrant communities view police officers, local police officers, as an extension of ICE, as ICE agents, they're less likely and they're more hesitant to call when they need help or when they see someone that needs help. And that's just a public trust issue. So that's something that, you know, they could do. And I've spoken to many you know, police departments, and some of them quietly tell me, you know, even with the ICE issue, some of them quietly, sheriff's offices have quietly told me, listen, we don't do this, but we don't want to be public about it. And that's fine with me, as long as, you know, that they don't honor ICE detainers, that's all I really cared about. Likewise with the victim witness stuff that we're discussing here. There are police departments that say, yeah, even Prince William has done this, which is surprising to me because, well, Charlie Dean, who was he was the police chief at the time, was just a really great police chief, and he made an internal document that said, we will not ask for the, you know, legal status of someone who's a victim or a witness to a crime. And I think that's one way in which law enforcement could cooperate and foster trust with immigrant communities and not bring ICE into the mix.
Anything else? If not, oh, great.
I had a question for Ms. Bauer. You were talking about HB 56, and you said that a lot of people continue to support the bill, even though information was getting out about what it was doing. I was wondering why you think, what was the motivation behind that? Was it simply ignorance, or did they just have a discrimination against immigrants?
I mean, I think that's a really interesting question because I don't think everyone who supported the bill was, you know, profoundly, you know, racist in their intentions, although I think some people were. We did some polling, actually, which was really interesting to me. And we certainly saw a substantial change over time as the issues came together. There's a very strong public reaction from the religious community, which in Alabama is like, you know, like almost everybody. And people who said, you know, we want to be able to feed people, we want to be able to give people clothing and housing, and that was made illegal by the law, so that was good. But when we did the polling, we actually polled about the different provisions of the law, the school provision that affected kids. There was a provision that made it illegal for undocumented immigrants to enter into contracts, to enter into any business transaction with the state, which was defined incredibly broadly. There was the kind of Arizona Papers, Please provision that basically allowed people to be stopped and always have ID on them, which resulted embarrassingly in the arrest of a high-profile white Mercedes executive who was visiting from Germany, which was like kind of interesting and fun for those of us who'd been complaining about it. But the polling was interesting because the thing that people reacted to, of 30 provisions, some of which, you know, including this religious provision, so you can't feed people, you can't house them. The thing by far that people reacted to and found offensive was the contracts provision, which showed me once again that, like, every time I have a jury trial, I have to have a focus group, and they always tell me that something I think is incredibly compelling is like just stupid, and they don't believe, and then they're really impressed with something else that I thought was unimportant. So that just really was very interesting to me. That sort of like that right that people have a right to enter into a contract, and you can't interfere with that. That resonated with people more deeply than the idea that we were interrogating school children when they went to school about whether their parents were undocumented. So I just gotta say, I can't even speculate about what it is that causes that to be a true statement. But certainly by the end of the time when the law was finally enjoined, a majority of Alabamians did oppose the law, and so I do know that.
Yes, Jesse.
So for people who do want to get out there and try to make changes, from your experience, what's the best sort of way to start having these conversations with local communities or with local, say, the police officers or law sheriff's offices? What's the best way to just start having these conversations to bring back change?
Okay, I'll start. Everyone's looking at me. So one of the ways that people can really be proactive is go to your local sheriff. I mean, you can request meetings with these people. These people aren't just untouchable. Like they're there to represent you and and to protect you. And I think that I've worked with a number of organizations and a number of individuals who are so gung-ho and such great advocates on the behalf of immigrants' rights that they would personally write letters, they would personally schedule meetings, they would discuss with them, their local sheriff or local police chief, what issues you believe in and how the police chief or the local sheriff should be addressing them.
Well, right, just to state the obvious, by definition, immigrants can't vote. So I always encourage people to think about that. Maybe in many communities, immigrants represent a sizable percentage of the population, but they don't have a voice in the political system in that way. They do have a voice in the political system in some other ways, but to think about that in the ballot box.
Great. Unless there is anything else, I'm going to thank our panelists so much for coming.